welcome to the Capitol Forum interview series. My name is David Blotner, and we are delighted to have David Balto with us here today. As background, David has practiced antitrust law for over 20 years with both the Antitrust Division of the Department of Justice, and he was a former policy director at the Federal Trade Commission. He's now in private practice, represents public interest clients, and is a senior fellow at the New American Foundation. David, it's a pleasure to have you here today.
Thank you, David.
I wanted to start off and talk a little bit about the merger guidelines. They've been revised a number of times, as you know, most recently in 2010. And I wanted to just ask you what you thought were the most significant changes in the most recent revision of the guidelines.
Well, first of all, I think it's interesting about how the process worked, and I'm really taken by Commissioner Russia's sort of dissent and commentary when the guidelines were issued, which was, these guidelines have been written by economists and we should be wary. And I think that's an appropriate instruction. Too often, I know for myself, having litigated cases both for the government and in private practice for defendants, the government relies too much on an economic perspective when they litigate merger cases, and when they don't sort of base things on the hard real-world facts, that often leads to their demise. So to the extent that the merger guidelines are too much of an economic approach and not enough of an approach on hard facts, I think they'll be somewhat problematic. What the guidelines tried to do, what the economists who were the key authors of the guidelines tried to do, was provide standards that more accorded with the standards actually being applied to the agency. So to that extent, to the extent they're more transparent of what's really going on, they're helpful. But to the extent they move the focus of analysis too much to economic factors and away from some of the real world facts, I think that could be problematic.
Let me ask a little bit about that. One of the things that the guidelines tried to do in the most recent revision, it seemed, was get away from focusing so much on market shares and defining, the exact relevant product market. Do you think that's a good thing?
I think we've got to differentiate between the agency's process and actually going to court, which is the ultimate crucible of determining what the law is. And what we have, remember, if we actually have to go to court, is we have hundreds of generalist federal court judges who see at most one or two antitrust cases a year. Mm-hmm. And when they open up those antitrust case books, the first instruction to them is define the relevant market, calculate market shares. So as much as the guidelines might want to move things away from that kind of approach, I think the agencies have to remember that when they actually litigate cases, they're still going to, the most powerful thing they have to do initially is defining relevant markets. The economists like the idea that you can demonstrate competitive harm or likely competitive harm just through direct evidence, and we can sort of skip over or passingly glance by the relevant market stage. That might work when you're negotiating a consent decree, but when the agencies have to go to court, that's not going to pass muster.
Well, let me ask a little bit then about sort of what the agencies have been doing lately. And it seems most of the more recent merger challenges have been with DOJ cases. So I want to just ask about those. They seem to be focusing a little bit more on trying to tell a story and using documents and so forth in the complaints. They did that with the AT&T case, with H&R Block, most recently with the AB InBev case. Do you think that's the right approach for the agencies to be taking?
Well, I wrote a recent article on this subject about the use of documents in merger cases. I think you have to be careful about the use of documents. AB InBev is an excellent example of how documents can be used effectively to go and tell a story about the business strategies and the likely business strategies going forward, and really put that into a context that's attractive to a judge. But sometimes documents won't take you far enough, and sometimes the agencies or any private plaintiff might want to try to tell a story with exclamation points and have some quote from some document, cut out and, sort of try to win the case based on that quote. And I think that's true of the Department of Justice's action in the Bizarre Voice case, in which most of the case seems to rely simply on snippets from old documents to really demonstrate competitive harm. And, we don't have to go back any further than Judge Easterbrook's opinion in the AA Poultry case, in which there was this great document in this predatory pricing case that said, we want to flush these turkeys. That's what, the monopolist said, putative monopolist said about its rival. And Easterbrook explains articulately why you can't rely on that kind of intent, because that kind of intent is, that kind of document expresses the kind of intent that may reflect both an anti-competitive intent, but also just the nature of competition.
And I was going to say that it seems to me that a lot of these documents are exactly the kind of things that you would expect people to write about. I mean, if you're a company and you're concerned about your competitors, you're going to be, trying to devise strategies and, doing things that are designed to help you compete. And so trying to separate out, as you say, when do we care about those documents and when are those documents just normal competitive chatter that we should not really pay much attention to?
Yeah, I mean, that's a very good point. In AB InBev, I think the documents tell a compelling story. One of the crucial aspects here is whether or not you could rely on Constellation as being a strong potential rival going forth. And the documents seem to tell a story that Constellation wanted the peaceful life rather than to sort of be an aggressive competitor.
And it seems now that DOJ is going to allow Constellation to be the buyer of the divested assets, despite those documents that DOJ highlighted in their complaint.
Well, DOJ has a tough task before it to make sure that Constellation has the full package of assets, so that it has the incentive and ability to fully restore competition. I wanted to mention one thing. An important trend here we see in antitrust enforcement over the Obama administration. The tendency in agencies in the past has been, is there some way, when they see a merger with some difficulty, it's sort of like, is there some way we can work this out? Is there some way we can come up with some divestiture in some regulatory fashion to settle things? I see a trend at the Antitrust Division in particular, where if they see an anti-competitive problem and they don't see see the merging parties really willing to offer up significant relief, let's go to court, let's get the case on file, and then let's negotiate a settlement. And I think appropriately the division realizes it's in a much better posture to negotiate a settlement once a case has been filed, rather than trying to just negotiate it as part of a regulatory process.
And I think that's a good point, because the number of cases, even though the division has filed more cases, the number of cases that have actually been litigated to judgment is still quite small. I mean, the H&R Block case is the only one that I can think of that they've actually gotten a litigated judgment out of, where the judge had to make a decision rather than the division settling the case or the case getting dismissed because the parties walked away from the deal.
Yes, but the willingness to go to court, which the division has in merger cases, which the division certainly has shown. You remember back the NASDAQ NICE matter, there was another matter filed right around then. The willingness to go to court, I think, puts the division in a much better posture to negotiate a comprehensive settlement.
I just want to ask you one other question about documents. One of the things that has also come up in some cases is the division is focused more on the merging companies' documents to try and figure out what their intent is, perhaps. There have been arguments made that if you don't find evidence in the company's documents that highlights the company they're trying to acquire as a significant competitor, do you then just assume that you walk away from those kinds of cases because they clearly haven't focused on each other as being each other's most significant rival?
No, David, I also represent parties that are trying to get mergers through, and when companies talk to me about mergers they're considering, the first thing I tell them is make sure you don't create any nasty documents.
Okay.
Let me just make one more point about the document issue. You know, you have to, as an enforcement agency, put the documents into context. For example, in the Bazaar Voice case, the documents are like 2 years old, and in an internet market such as the one Bazaar Voice participates in, that's ancient history. The second thing is, in every deal, you're going to have this MBA working at the corporation who's 2 years out of business school, who's going to try to justify the transaction in the most colorful fashion possible. Right. And that doesn't necessarily mean that that's actually going to happen. You know, in the Baker Hughes case, merger case back from 1992, when both of us were practicing
right.
at the Antitrust Division, there was a great document by the acquiring firm saying, we need to do this deal because we're going to be able to raise prices. Mm-hmm. Well, the judge rejected the challenge to the deal. Baker Hughes acquired the other firm.
Right.
Was it able to increase prices? Nope. Mm-hmm. He was wrong.
Right. There's been a lot of other kinds of evidence that they've focused on. For example, econometric evidence has been significant in a number of cases that the division has brought. What do you think of the focus on that kind of evidence, and is that the kind of evidence that is essential now to have if the division is going to bring a case?
You know, I think econometric evidence is like when you serve up a really nice meal, having some nice garnishes at the side. You know, you still want the food to nourish you, and maybe you feel a little bit better because there's some attractive garnish. I think if you look at the cases that are actually litigated, some rely somewhat on econometric evidence, but it's almost always after the court has explained, here's this competitive story that they really buy into. And then the econometric evidence is just padding to support their decision.
So do you think that it's important for the division to develop that evidence, or do you think that, as you say, it's just a garnish and they can live without it?
I think it's just a garnish that they can, that's helpful to have, but not essential.
Okay. The economists probably won't appreciate you saying that, but I appreciate your thoughts on that. You've been representing third parties primarily in a lot of merger investigations. I wanted to just ask, how is it that you approach the agencies when you're representing a third party to a merger transaction?
Well, what I want to do is, first of all, find out from my clients what their concerns are, and then what they would like to see happen out of the investigation. It's important to understand your client's goals and try to represent them as best as possible. Second, we try to be as substantive and factual as possible, but our clients are typically small businesses, consumer groups, mm-hmm. farmers, people like that. We don't have access to great information. We're not going to walk into the Antitrust Division or the FTC with a highly paid economist or things like that. So we make it clear what the limit to the agency, what the limitations of our information are. Third, we want to know the law and the enforcement actions the agencies have brought as best as possible, so that we can say, here's an enforcement action we think is necessary, and these are the reason why it's supported by your past actions.
So what's the most effective approach to the agencies then? I mean, what is it that the agencies want to hear that is going to resonate with them as they're trying to evaluate a merger deal?
I think most crucially, we want to tell the agencies that if they have to go to court, here's the evidence that they need, and we can provide it for them. To help support an enforcement action. I think that's generally the most critical thing. Okay. And then explain why the public interest will be served. So we haven't differentiated about whether or not I'm representing a competitor, which I do in some cases, mm-hmm. or just customers or just third parties like distributors. It's always, no matter who we're talking about, to explain why ultimately consumers are going to be worse off because of the merger, and why whatever we're proposing is necessary to support the public interest.
And you represent clients that appear before both agencies. What differences do you find in dealing with the Department of Justice versus the Federal Trade Commission when you're bringing in a third party to a merger investigation?
You know, there are really interesting and subtle differences between the two of them. First of all, when we pass the level of the actual staff attorneys, if we talk about the ultimate decision makers, when I'm at the commission, I have five commissioners
Right.
of different parties. So that creates many more opportunities for advocacy, and it creates the opportunity for dialogue between the different commissioners, which oftentimes provides opportunities for us. Second, we tend to get more involved, perhaps at the remedy stage at the FTC, because they have a separate compliance branch. I think both agencies are concerned about litigation. I think that's more of a concern at the Antitrust Division, which seems to be more litigation-oriented. So our presentations to the Antitrust Division usually tend a little bit more to assume that there might possibly be litigation. A fourth difference is the DOJ will deal with regulated industries such as cable or telecom, and so in those situations, we're dealing not only with the DOJ but the FCC, and we're sharing we're trying to sort of help educate both the agencies about each other's issues.
Okay. Do you ever encounter a situation where third parties that you represent are concerned about talking to the agencies, fears of how it'll affect them in the future if the merger goes through, or concerns about just what may happen to them as a result of the deal?
Sure. I mean, third parties are always concerned about talking to the agencies and the fact whether or not that gets back to one of the merging parties. And some of these situations can pose significant concerns. Assume an acquisition by a firm that's fairly dominant. Mm-hmm. Do you really want to upset them? Assume that perhaps I represent somebody who has a relationship with the merging parties. They're a distributor. They're very concerned about what the impact might be on them as on the merger. Mm-hmm. And so there are limits sometimes about the degree that we can really be helpful to the agencies.
And how reluctant do you find people that you represent are when it comes to sharing what they know with the agencies?
I think once they understand the confidentiality requirements that are imposed upon the agencies and how the information they provide can lead to a decision that will be beneficial for consumers and also beneficial for them, and realize how their goals can be met, I think we can get over that reluctance.
Okay. So the last thing I wanted to just talk about is just generally the experiences that you've had over the years in dealing with different administrations. You kind of indicated a little bit about that there's always that issue with the Federal Trade Commission where you have Democrats and Republicans that are commissioners. But in general, how have you found the two agencies to differ over the years as you've practiced in front of them?
Well, I do think politics matter, and I've written a number of articles to that effect. And too often, people who look at the political nature of antitrust count the number of enforcement actions. And though statistics matter in baseball, I'm not so sure how much they matter here. Mm-hmm. So to give you an example, I do a lot of work for farmers. I'm extraordinarily proud of the work I do for farmers. I know how difficult it is for farmers to provide, to be able to compete in the market and deal with very dominant processors. The Antitrust Division hasn't brought many enforcement actions on behalf of farmers, but through the change in administrations, I see a tremendous increase in the amount of resources and especially hard thinking and hard work being put into agricultural antitrust issues. Mm-hmm. Sometimes it's not just what enforcement actions are brought, but just the level of commitment. In terms of the agencies, clearly there is a significant increase in the level of litigation, and I think that also the comprehensive approach to merger remedies in the current administration, and I think that really leads to significant benefits for consumers.
I mean, there's been a lot of discussion. As you say, the administration has been focused on agriculture. They held a whole series of hearings on agriculture and went out and got views on agriculture from everyone that they could get to come and speak with them. And I'm still not sure at the end of that process that Antitrust has figured out exactly what their role is in agriculture markets these days. What's your view on what the role is for Antitrust to play in agriculture markets?
Well, first of all, I do think there are additional enforcement actions the Antitrust Division can bring. There are private plaintiffs' cases that have been successful. The division should look at those cases as being examples of the kind of cases they should bring. But one of the critical insights former Assistant Attorney General Christine Varney made was there is not an antitrust solution to every competition problem. And sometimes we should be looking towards how to use regulation to go and solve competitive problems. And I think this is a prime area where that's true. And there's a lot that the division can do and is, I think, attempting to do in working with the Department of Agriculture to improve the regulation of some of these agricultural markets. And I think that may be part of the solution here.
I just want to thank you for speaking with us today, David. It's been a pleasure, and I hope we can do it again soon.
Thank you so much, David.
Thank you.